Hi, hello. I'm Dr. K. Pungode, Assistant Professor in Department of Commerce. Now we are going to see about the elements of contract over here. So we are having a different types of elements in a contract. What are the different types of elements in a contract? We are going to see now. So contract is one. I hope you all know about the contract. Contract is an essential to this modern world, and we are having a different types of contract over here. And the before slide we have seen what are the different types of contract we are having. So now we are going to see about the elements of a contract. What are the different types of elements of a contract over here? Elements of a contract, it includes both the things that, so each and every contract must have a some of the things over here. So what are they? That first one is that we should have offer and acceptance over here. So what is an offer and what is an acceptance? So offer and acceptance means the one party is accepting a contract, another party is offering a contract. So that is known as offer and acceptance over here. So it is one of the most important thing in each and every contract. And capacity of a contract over here. So the capacity of a contract is also most important thing. So whoever can come into a contract is not a meaningful thing. There must be a capacity to that. Minor cannot enter into a contract. So we have to make sure that who is the most important person can enter into a contract. Based upon that only we have to make a contract deal in a business. So that is a contract or a capacity. Next one is consideration. For each and everything, consideration is one of the most important thing, and it takes place over here. So something in a return. So both the parties involved in a contract, one is getting a thing, both the parties is getting a benefit over there. So that is a something in return. One person is giving one thing to another person. The next thing is that we should have a free consent over here. So we should not have any other consent. It must be a free and flexible over between to the parties. Next one is it must be a lawful thing. So lawful consideration is most important thing over here. Next is performance of a contract is also most important thing. There must be a legal obligations and competency should take part in an elements of a contract. The validity is also one of the most important thing. Whether it is a valid contract or an invalid contract, there must be a legal rights over here, and they have to have a contract before that entering into a contract. And also they have to make sure that the different types of contract and how the importance over here helps to understand the legal rights, useful in business and trade, prevents the dispute, protect the legal remedies, ensures the smooth transactions over here, advantages of a contract, legal responsibility, and also it builds the trust and helps business growth, etc., and reduce the misunderstanding also. Next thing is that disadvantage of a contract, it includes the less expensive, complex drafting, risk of disputing, time consuming process, etc., comes into here. The next thing is the contract or essentials in the most important this. So each and everything enter into a contract. So based upon that we are having a different forms of a contract over here. So we have to follow the following elements, that is a rights and duties of it. So first thing is that there must be an agreement, it must be an offer and acceptance, and we should have a free consent over here, uncertainty and consideration, expensive, valid, war, it should be a valid contract. These are all the points we should take into an account. So the contract is a legally enforceable agreement between the two or more parties, and it creates a legal obligations and rights between the parties involved. When one party fails to perform and agree the term, the other party can legally remedies through the court over here. So these are all the things involved in an agreement enforceable by law of a contract over here. Once again, and conclude with this, the valid contract must have features of two parties or more, agreement, legal obligation, lawful consideration and free consent. It should obtain the force, frauds and pressures over here, and then it should have a competitive parties over here, and it must have their force and offer over here. Both the parties are agrees willingly, the object is legal, and consideration exists over here. So the defines the duties and responsibilities and importance take place over here. So these are all the different things involved in an elements of a contract. I hope you all understand about the contract and elements of a contract. Thank you.